Hey everybody, good morning. My name is JD Houvener, and you're to the welcome to the Bold Today Show, where we've got a program we put on weekly, and I'm here every Wednesday, 9 a.m. Pacific and noon on the East Coast, talking about patent law. And we're here again. We're talking about 2021 already amongst us. We're almost at the end of the first month. As time is flying by, and as I set up to do this podcast, on Monday, I really wanted to. I just felt optimistic. I felt there's a lot of things going well in the world, in the U.S., and especially in stark contrast to how things went last year. We've got really nice light at the end of the tunnel. Okay, and it's not the brightest light, but we've got vaccines on the way. People are already being vaccinated. There seems to be a path to success here. And like I said, a light at the end of the window for COVID. There's just a lot of good news. A lot of people are interested. We've had the most amount of traffic to our website. Hey, Michael, good to see you. People commenting, asking questions on Facebook about inventions. We've had a pretty good showing here on this weekly live, which is pretty awesome, from our YouTube, our Twitter even, and of course our Facebook communities. So welcome all. This is a Facebook Live, so I do want to launch a disclaimer that if you've got your invention and you want to ask about it, please know this is not the place to put a confidential disclosure of your invention. Okay, this is just more for high-level patent process questions. Keep them hypothetical if you would. We're all going to learn together and have some fun. I wish I could have a guest on today. We don't this week, but we will next week. We're going to have a feature sort of behind the scenes at Bold Patents. So we're going to feature one of our employees. Not sure exactly who it is yet, but we're going to announce that early next week to kind of show you what we do, a different face other than my own here on this channel. So for those that are new, those that are coming in or maybe watching after the fact, this is a Q&A, kind of a casual, informal session where I'll field live questions from our audience from across YouTube, Twitch, and Facebook, and I'll prioritize those questions. If we don't have any questions, I'll jump to our Avvo questions. So anybody listening from avvo.com who asked a question, you can kind of fast forward to the end of the program, where I usually go through about 4 or 5 questions as time allows. And of course, if we have a guest on, we'll do that as well. So today the theme is, an optimistic sense of 2021. And for those that are just now joining, I'm JD Houvener. I'm the managing partner and owner here at Bold Patents Law Firm. And I'm registered at the USPTO as a patent attorney, and we run a boutique patent firm where we help do all these things, right? We help with patent research, patent drafting, office actions, and helping you all the way to getting that world-class patent locked in for making that a cornerstone to your business, to make it a success in the marketplace. So let me put that disclaimer up on the board just so you guys don't forget. Please do not share any confidential information in this live session, but fire away with those questions that are more generic, and maybe as you come up, as I mentioned something, I will prioritize any live questions that do come in. All right. And if you feel so compelled, I do want to throw this up right now. I'm offering a copy of my book, Bold Ideas, The Inventor's Guide to Patents. This is a book that I wrote myself just a few years back. It's got a lot of really good nuggets, and a PDF copy is yours if you take the step to schedule a free screening session with one of our advisors to see if patenting is the right time for you. All right. I think, honestly, I know it's cheesy to say this, but I think everyone is an inventor. Okay, it's just a matter of whether you want to move forward with your invention or not. I think we're all creative humans, we're all creative minds, and we have solutions in our heads. So I'd love to have a conversation with you to see if now is the time you want to launch and make 2021 the year that you move forward with your invention. I had a couple of things I wanted to talk about. Whether you're staying out of the politics, I think it's refreshing that we have a president that got inaugurated. We're on to a 4-year plan. We're going to trust him as the president to lead our country, and it really went well. So I was really pleased to see that last week. So I think that's an optimistic point as well. I took a note here. The second round of support is coming through from our Congress to get those that are unemployed, to get them, compensated and paid, keep those extended, as well as those businesses that were impacted by COVID. I mean, thinking of restaurants and some of those, they're getting a second round of stimulus, which is really cool. So I think it's very optimistic that we got that done just this month. Something else to be happy about is, the fact that we have, a brand new year. Okay, this is the year that we're hopefully going to come out of the COVID crisis, right, and all get vaccinated, and in a way get back to the way things used to be and should be, or meeting in person. So I know we're all hoping for that, and I'm hopeful as well. All right, so let's jump into a couple questions we got from our Avo community. And all I want to do is share my screen so you can see these questions with me. All right, I'm going to share the whole screen. There we go. Okay, so for those that don't know what Avo is, it's a really cool platform where people can come in and ask anonymous questions to attorneys, and attorneys like myself will volunteer and answer questions as they come up. And so this one is in the patent application field, and there's just one this week. So let's take a look at what this is. It's coming out of New Orleans, Louisiana. And the question is, how can I sue for my patent? In 2019, I was told it takes 2 to 3 years to prototype and it costs $200 to $1,000 to have it be protected. My product idea was stolen for COVID-19 sanitization, and I've been in the cleaning services for years. Oh, wow. Okay, well, I mean, this is kind of a multi-point question. I don't know if exactly I'm honing in on what it is, but I want to just address a few things in that 2020 was an enormous year for personal protective equipment, including masks, cleaning devices, hands-free technology, an extra boost to sort of the smart home innovation. So we saw a ton of that, and definitely including solutions, formula for cleaning, antibacterial, antiviral, different types of approaches to cleaning. And certainly this inventor has been in the cleaning services for years. Okay, so they're part of that trend. So they mentioned 2019. I don't quite get what they're saying there, but it looked like they had put a lot of effort into prototyping the formula or the cleaning solution. And it's a product idea they have. So, one of the things I worry about is that during that prototype, that 2 to 3 years window, one of the first questions we ask inventors is, gosh, has your invention been published or sold? Right? Have you told the public or launched a website or a Kickstarter or Facebook community about what your product does? And if so, has it been more than a year? And if unfortunately it has been more than a year, you're not going to be eligible for filing your patent because it's already been over that 1 year. It's a strict bar to patent protection if it's already in the public domain. Okay, it's already part of what the knowledge you've given, right, as perhaps unknowingly for more than a year. So hopefully the answer is that you've kept it confidential and you've done that prototyping and kept it in-house. Let's assume that's the case. Now you say the idea was stolen. If you can actually point to an individual or a company that you disclosed in confidence, right? Had them sign a non-disclosure agreement, share the invention with them, and then they went and stole it. In other words, they took it and defrauded the patent office and said it was their invention. And you can prove that they derived it from you. There is a mechanism at the Patent Trial and Appeal Board to go under the derivation proceeding, right? And prove to the patent courts that you actually were the one that conceived, invented it, and they derived the invention from you, right? So back in 2013, the laws changed from first to invent to first to file. So, you're sort of out of luck if someone else totally independent from you, right, did not derive the invention from you and then filed that same invention, okay? They are going to win even though you invented it first. So that's the way the law is set up today. But if someone truly did derive or steal that invention from you, there is a path to claiming ownership of that. So very interesting question. Thank you for that. Let me go back and see if we have any live questions from our Facebook community here. Yeah, Michael, all right. So would you be willing to offer a review of my response to a USPTO office action? If so, what's your pricing term? Yeah, Michael, we do. We offer a screening session. Okay, so we're gonna first make sure that you're the type of invention, the spot, the type of business entity you have is something that we want to take on. And if you've got an office action that you've prepared, I'll want you to supply the office action itself that you got from the examiner, as well as your draft response, and submit that to us, and we'll schedule you for an attorney consultation. We do charge a $200 fee to speak with an attorney for a half hour. And part of that, right, with what you get is a review of any documents or information you send in advance, okay? And so to get that started, we will want you to go through our screening session. And I did provide that link right above. You'll see that calendly.com link. So that's a screening session. That's free. Okay, that kind of makes sure that you're a good fit for us and the timing's right. And if it is, we'll then schedule you for that paid consultation with the attorney as sort of the next step. Thanks for your question, Michael. All right, let's jump to our second OVO question. I'll go back to sharing screens. Feel free to follow up, Michael, if you have any additional questions. Be happy to jump to those. All right, we have just one patent question, so we're going to go to a couple of trademark questions here. This one is actually two out of Arizona. The first one's out of a city named Safford, Arizona. And the question is, can I co-own a club name and how to start the process? A good friend and myself want to start a club and have a name for it, but we're not sure if both of us can co-own it, as well as how to start the process if it's possible. Good question. So there is a difference between the applicant and the owner, all right? Oftentimes a trademark, it's important, it gets mistaken for just a name that's sort of loosely attached to whoever pays for it. And that's not true, right? Trademark is by definition attached to a business, okay? And the purpose of a trademark is so that it conveys, right, explains, helps a customer know where the goods or services came from, okay? So that has to be attached to just one business. And so, or club, right, any enterprise that is in commerce. And part of what the Trademark Office will require you to do is demonstrate that you're actually in commerce, that you're selling and offering your goods or services to customers. They'll make you provide a specimen, okay? And so part of that process, you will have to demonstrate the company, right? The ownership structure of the club or the company. That's where I think is going to be most helpful for you, for the question asker, is that it's all about how that club ownership is structured. So if it's just you and your friend, well, you want to make sure that that company, you call it a club, but it's likely a formed LLC or a partnership, that there's a contract that explains who owns what, right? Maybe it's 50-50, maybe it's 20-80, whatever it is, that is the ownership of the company. And the ownership of the mark is owned by the company. Does that make sense? So it really isn't the actual mark itself owned by individuals, it's owned by the company. So it's sort of a two-step, two-layered approach. Hope helped to answer your question there. We'll do one more question also out of Arizona. This is the Glendale, Arizona area. And the question is, how do I discover if I have a copyright or trademark on a business name? I forgot if I got a trademark on my business name and logo. Cool. Well, I'll just show you a little bit of that right now. You go to TESS. TES, that's Trademark Electronic Search System. And you can conduct a basic word mark search. Really, anybody from the public has access to this. And the question here was, how do I know if I've got one? Well, generally, if you do, but if you truly forgot, sometimes I guess I forget how many marks we have. So I'll type in bold IP, okay, into the search box. And there it is, okay? We've got our trademark registration. You can see that it was filed back in August 2014, and it was published in 2015. We have basically owned the rights to using this name for legal services in the United States, and covering mainly intellectual property law, patents, trademarks, copyright, trade secret. And so that's really all it is. It's a simple word Boolean search, and you just type in the actual term you want to, and you get baskets. I don't know. And you get lots of different results depending on how specific your terms are. Okay. And you see in this engine they'll have live, meaning they're active. Some are dead, which sort of a bit of a morbid term, but it just means that the mark is no longer active and there are no rights attached to it. As part of the trademark maintenance program, you do have to pay to maintain a trademark, and so that's what happens with some of these, is that they're not maintained. In other words, the businesses have probably gone out of business, and they don't want to simply pay for the rights any longer. All right. So let's jump back and see if we have any live questions. I do see a couple here. Let me stop sharing. Oh, but they're in. Oh, here we go. JD, can you check my allowance Flavio. Hey, Flavio. So, that is going to be something you should email in about. All right, Flavio. So send me an email. I do think that's kind of client specific. Just in case you don't have my email and anyone else that's curious, I do check it pretty often. That's my email address. Shoot me a note if you got something confidential, something you want to talk about. We'll definitely take care of you, even though you're not a current client. I don't mind doing a little bit of paying it forward, so I'm happy to do it. All right, let's see if we've got any other questions here on our AVO questions. Screen share. All right, a couple more trademark questions. There've been a lot lately. Okay, out of San Antonio, Texas. I'm making custom grinder tops, and I'm going to put a pot leaf logo on it. Is it legal to sell? Hi, I'm making a 3D printed plastic cover that goes over generic grinders, and I'm going to put a pot leaf logo on it. Is it illegal to sell? I'm located in Texas. Okay. Well, it does depend on where you got that logo, right? The pot leaf logo. If it's artwork that you created, then you have copyright in that, okay, as an artist. And certainly you can definitely give yourself permission to use that on a cover, okay? But if you've got that logo or that design from somewhere else, you will want to make sure that you're clear about who has the rights to that artwork. And if there are any copyright attached to it, you'd want to seek permission. And sometimes that does come with paying a fee. Okay, so lots of different ways that could work. But the logo itself, if it has words on it, okay, that may also have issues, right? Because with trademark law, word marks, right, which is actual English letter words, carry weight. And so if someone else is in the cover or the grinder industry, or even kind of in a more generic, high level, herbs or paraphernalia. I'm not sure what exactly a grinder is anyway, but that whole industry, if they're in that and they're using some of the same words that you're putting in along with your leaf, let's just say it's top weed. Okay, maybe there's another company that's already got a trademark registered with the word top, and they're well known for top, and that's been their mark for years. If you have the words top, on your cover, that may be an infringement, something we want to take a look at. So I encourage you to work with an attorney. Certainly, we'd be happy to help look at it with you to see if there is indeed potential infringement on what you're planning to go to market with. So thanks for your question. All right, last question out of Pennsylvania. Do I need multiple trademarks if I have a specific product name and I want to use under my already registered fictitious name? I have a business name registered as a fictitious name already and was looking to trademark my business name. I also have a product with a brand name and I want to use under the fictitious name. For example, McDonald's is the company name, but has the Big Mac that they sell. I want to see if I need a trademark for my Big Mac or if I would just need a trademark for the company name, which would cover the Big Mac. It's eventually, I think if you get enough traction in the market for your product, you will want to seek a trademark protection for the product as well. But that's kind of the short answer. And it sort of takes a little bit of time, to make sure that the product itself is going to be one that is successful in the market. If the McSquare is a new type of a burger, they may not seek trademark protection for McSquare until they see that it's popular, right? And that it's going to be something that customers like. The whole point is that if McSquare is great, they want to prevent competitors from launching something similar or going after that mark. If they want to be most conservative, and a company like McDonald's has really deep pockets, it's likely they would probably just file it in advance, just in case it becomes successful. I think for most entrepreneurs and startups, paying for, and registering marks just in case they're successful isn't always something that's in the budget, right? So it's sort of it's a call for the business owner to what degree they want to make a risk, right? The risk is if you hit the market with a new product name and you wait any amount of time during that period of pendency, a competitor could try to grab it, right, and claim it, or someone else could independently try to file for that mark and in a way force you to change the name. So hope it helps a little bit. Let's jump back here and see if we have any live questions that came in. I don't see any. I did want to take a moment. I forgot to share this. And thanks for the like, by the way. If you guys are appreciating this, the fact that you got a patent attorney here answering questions and you want to kind of increase the folks up here that are doing live, share this with your community, give us a like, and we'll try to get some more people involved. Okay. Yeah, let's see. So Flavio, how did some marketing companies already get notice of my granted patent? Mail came together with the patent award letter. Yeah, they're good. I'm jealous of how good they are at marketing. There are a lot of companies, they'll get notifications from the patent office that there's basically an issue, right? There's an issue notification that goes out that is part of the public domain, meaning the patent will be issued, 30 days from now. So these marketing companies must have some automated way of getting their direct mail, right, and their email together to launch and send right at the same time that you receive your ribbon copy or that you receive the news. Not all marketing companies are bad, right? They're being aggressive because they want you to hear what they're doing. I would just take a look at it, see if what they're doing is valuable. Check with your attorney to make sure that it's valid. There are a lot of spoofers out there, but I'm not against marketing. As you may have known, I market really hard, right? Our firm, as a law firm, it's pretty rare for law firms to be, as marketing is hard selling in a way as we are. But I do it because I know we have an amazing product. I know we have an amazing level of service that inventors need. And so I want to shake the shoulders of as many inventors as I can and say, don't go to Invent Health, right? Don't go to LegalZoom. Let us help you, right? Because I really feel passionately about that. And so perhaps that's how these other companies feel. All right. So last 5 minutes, I wanted to share that we do, I am going to be saying goodbye. We're all saying goodbye to Andre Iancu, who is the current USPTO director. And that's a shot of him there. He served for 4 years at the USPTO leading that. I think he did an amazing job. I actually had the opportunity to be on a podcast with him and ask him questions. So it was really, really special. That was back in 2018. He did a lot of things for patent owners, right? Since 2014, the Supreme Court really hasn't been that pro-patent owner. And so he did a lot of things in changing laws and starting the trend toward really helping the small and solo inventor get and acquire and keep the patents that have been awarded by the Patent Office. And they've also reduced the amount of time that patents have been pending. We've actually seen more patents get through the patent system in a year or two as opposed to 2 or 3 years. So there's really been a vast improvement. He actually had a speech he gave just a week or two ago. He had a couple of really good quotes that I thought were just inspiring. I have seen him speak live as well. So he had a good quote. Let's start with this one here. Albert Einstein, okay, an aging Albert Einstein told one of his friends, "People like you and me never grow old because we never cease to stand like curious children before the great mystery into which we were born." Love that, right? Keeping a childlike wonder, okay? Alexander Graham Bell was quoted to say that he was like a little child to whom his little world was a wonderland, as it is possible for a great man with a great mind to be. Nikola Tesla said that he desires that guides me in all I do is a desire to harness the forces of nature to the service of mankind. And just really, really powerful stuff. And some of the most famous inventors of all time had that curiosity, right? Just that innocent, that wild wonder. And just so fun to hear that and see that in all of our clients. And if any of you out there that are wondering whether your invention can make a difference, it can. And I think, you're welcome, Zen. No problem. Good to hear from you. it definitely can. You can make a difference, and you're challenging the status quo. Kind of like Steve Jobs, right? His famous commercial, right? He's part of that rebel group. You don't have to be, go get a job and be an employee somewhere forever, right? You can have that and should chase that dream. So I'm really proud and honored to be a part of that for a lot of our clients, and hopefully some of you that are listening out there. So with that, I'll wrap up and let you guys get off to your day. But thank you for joining me for this live broadcast. I'll be back next week with one of my employees, someone from the inside of Bold Patents. I'm excited to share that with you. Keep the questions coming. Thank you all for joining, and have a good rest of your day. Go big, go bold.